Yeah. So I rise to support the Social Services Legislation Amendment, Child Support and Family Assistance Technical Amendment 2024. We know child support is often a fairly vexed and contested area in family law. Sadly, having practiced as a family law barrister, I know very much it's often an area of quite acute contention, where there are fears of control and abuse that come from the debates and the arguments around the payment of child support, where that financial insecurity of a parent with the predominant care of a child finds themselves, and where that payment of child support can be used as a tool to manipulate and control and harass. But then there is also the vexed question where people feel that the system is taken advantage of to withhold time in exchange for greater payments and support through child support. So I think there's been there has been an incredible number of inquiries looking into our childcare system, the child support system, and there's been a number of recommendations around how do we make it fairer, but also more reflective that ultimately parents bear a responsibility, a financial responsibility for the children they bring into this world. And as such, that responsibility remains, regardless of changes of circumstances, of breakdown of relationships, of decisions to remarry and have further children. That responsibility, once you have had children and brought them into this world, remains. And I don't know that the system currently properly reflects that. I support this amendment in terms of this tweaking of the rules, but I would encourage the government to go further and to look more fully at this question, because it is vexed and many people feel very, very strongly about this system. Currently, child support payments are calculated based on parents' total income divided by the proportion of care they provide to the child or the children. A set amount is subtracted for parents' own costs, and then payments are worked out using a cost of children tables. For example, parents' own cost is often a vexatious question depending on repartnering and whether further children are had, and what additional, costs come under the parents' responsibilities. Then also the cost of children tables are problematic because it's very hard to say a one-size-fits-all meets the cost of children, especially if there are special needs or additional considerations. And so you often can see the tension in this system. The parents' own costs are calculated by a measure called the male total average weekly earning. So I would urge the government to consider amending that descriptor, because even just in the way that is described just says gender bias there and then loudly. Our Warringah office hears from single parents struggling with the cost of living and some additionally impacted by the unfairness of the child support they receive or pay, not aligning with the percentage of care that they are doing. We have heard from single parents who have the added impact of domestic abuse, and they want policy that takes into consideration the financial impacts of this. And I commend the government and the Attorney-General, who has already introduced a number of reforms when it comes to the Family Law Act in relation to where domestic violence interacts with the system. But today, the technical amendments on this bill provides for an opportunity as well to talk about the broader issues with the child support system. The child support system in Australia is decades old, and I would argue needs wider, more fundamental reform. It's a fact that today 40% of marriages end in divorce, and a number of non-marriages, relationships as well. So it is sadly a frequent event that there has to be, on breakdown of relationship, a sorting out of that financial responsibility to children. According to the Australian Institute of Family Studies, the proportion of divorces involving children under 18 is 48%. So very, very frequently, children are involved. People are impacted by the breakdown of family relationships, and the current cost of living pressures is adding to those pressures felt by single-parent families. Sadly, as an advocate, I saw all too often financial pressures brings on the breakdown of relationship, but the breakdown of relationships exacerbates and brings on greater financial pressures on the individuals involved. Caring for children costs money, and the higher percentage of time that parents have with children in their care greatly impacts their weekly expenditure. There's no doubt about that, and so I urge the Minister to review that table when it comes to the cost of the child, because some of those formulas, I would argue, are quite outdated and certainly don't always take into account all the particular circumstances of a child. We know as well that unfortunately the payment of child support is also frequently weaponised, where it is used to withhold support, to impose a level of duress on the ex-partner and by association the child. And too often the parents are so involved in the conflict they lose sight of that ultimately the person paying the price is the child, and they ultimately have a responsibility to that child for having decided to bring that child into this world. About 1/3 of all parents paying child support have fallen behind, and it is predominantly men that have that liability. Collectively, they owe some $1.7 billion in unpaid child support. More worryingly, we know that the non-payment of child support or the withholding of child support can be used and abused to jeopardise financial safety of single parents and children. A 2023 report by several academics called The Weaponisation of Child Support in Australia highlights some very stark issues with our current child support system. Following separation from their partner, if not always women, but more often than not it is women, women are faced with ongoing financial abuse. And we know there is now legislation introduced into our several state jurisdictions to start addressing coercive control and those kind of issues, but we shouldn't have a system where a government, a legislated system such as child support is used as an additional abusive tool. So we know, and as the statistics show, abuse primarily affects women who continue to carry the burden of unpaid care work in Australia, and they are overrepresented in victim survivors of family violence. The way the child support scheme can be weaponised means the results can be devastating for mothers and their children. According to the weaponisation report, 80% of women had reported that their ex-partner had replaced physical abuse with financial abuse through the child support system as a way to assert coercive control. Ex-partners' coercive control was enacted, according to study participants, by threatening to reduce child support payments and/or not lodge tax returns to deliberately lower payments or avoid payment increase, or simply work off the books so that it is not reflected in a liability to child support. This stands in stark contrast to what the system was set up for, which is to ensure that children are financially supported by both of their parents following a parental separation. So the bill at hand identifies and deals with what Services Australia identified in 2023, concerns that the 2018 amendments to child support and family assistance legislation were not operating as intended because of unclear drafting. So instead of strengthening interim period provisions, the 2018 amendments unintentionally limited the circumstances when interim period can apply. A federal court ruling in February found this to be the case, and under the current legislation, an interim period can only apply at the start of a new child support assessment or family tax benefit claim where the breach of the care arrangements occur at that point. Under the amendments in this bill, a broader range of circumstances when interim periods will apply for child support parent payments. So what are interim periods and why are they so important? Well, they're often used as part of court orders to determine a percentage payment that a parent must make as part of child support arrangements. Now, depending on where that level of care is established, depends on the size of the child support payment. Interim periods are also used to ensure a parent withholding care does not financially benefit through higher family tax benefit payments. Now, I should note that there's been changes to the family law through the Attorney-General and amendments in relation to that withholding of time and contravention of orders. And there is this horrible nexus between abuse of the system of withholding care at times and then seeking to increase financial support or child support payments. And too often parents already in a high conflict situation feel that the other is using the system to punish or to abuse or to take advantage. We need to make sure the system works in a way that avoids those kind of situations. And so now what we can have, well, what's simplified is that an interim period where care might have changed or there is a withholding of time prior to it being decided by the courts are not used to ensure the withholding of care to financially benefit through a higher family tax benefit payment and impacting child support. So I will support this bill. These amendments are important and they affect a large number of Australian families. Families don't need the added stress and time of chasing up payments that they are entitled to. Invariably it is single parents and invariably it is women. It should be up to the government to make sure there is a fair system in place. The amendments to this bill would see existing rules apply to protect children and parents at risk of domestic and family violence. If a care arrangement has changed due to a fear of violence or neglect, Services Australia is able to ensure that child support and FTB payments are based on actual care and an interim period would not apply. So I understand that under the amendments, changes will be put in place to make sure that interim period decisions made since 2018 legislation will be brought into line. And this should be done to minimise the impact on parents and carers who may otherwise be financially disadvantaged by having these decisions disrupted. But where can we go from there? Well, I would argue to the Minister we certainly need to review the definitions used in the Act, and that a definition that identifies a male total average weekly earning is problematic and should be changed as a matter of just definition. But I think we also need to look at some of the issues identified in the 2023 weaponisation report situation. The government could look at the feasibility of implementing a guaranteed child support payment, whereby the government can underwrite and pay upfront the payment of child support and be the recovery agent, as it is from a tax point of view, towards the parent with that liability to pay. This would take away the pressure and responsibility on single parents already struggling and dealing with the impacts usually of domestic violence and abuse, from also having to be the cop on the beat to go and collect that child support payment. The government would then seek collection of payments and enforce compliance on the payer, whilst ensuring that violence ex-partners are not rewarded for abusive behaviour. We do it through the tax system. The government, via the tax system, does that recovery of payments. It would be an assistance to single parents for the government to step in this way to underwrite. You would not have a situation of single parent families, frequently women, going without any support and the responsibility of meeting the costs of the children. Finally, so the current formulas used within parts of the child support system, as I've said, are out of date. The current formulas don't properly reflect the costs of the child and the cost to the parent that is primarily caring for that child. The current formula in this instance reduces a financial contribution, for example, to the children they already have when there is a change of circumstances, and sometimes the decision to have further children, and you have then a situation where the cost of the existing children falls disproportionately to the other parents. This again gives rise to added tensions that I think should be better addressed. There are many situations that have been investigated and the panels established by the government in 2023 could look at. One is the Child Support Stakeholder Consultation Group. They will provide a direct voice to government on issues impacting families, and I look forward to seeing what recommendations come out of that system. The membership includes national peak bodies and organisations who represent separated parents and their children, or provide services, programs and other expertise related to separated parents and their children. Then there is a Child Support Expert Panel. The expert panel includes academics with expertise in child support research, family law and expenditure data. Their scope is more focused and technical in nature than the stakeholder group, and they will provide oversight of research into the cost of children and develop a methodology to review the child support formula on a more regular basis to ensure it continues to reflect the cost of raising children in Australia. I think there is fundamentally some problems with the system. It's very difficult to come up with the right formula. I don't think there's any government that's come up with a magic wand, but there are definitely tensions where child support payments are linked to nights of care because parents sometimes have daytime care of children, and that does, and there is a sense of a disproportionate financial burden versus a time burden. So I am encouraged that the Minister is engaging with the issue. I would urge the government to go further and to try and bring the child support payment up to modern day standards.